Government corruption defendants Art San Agustin and Tom Nadeau want Superior Court presiding Judge Alberto Lamorena removed from overseeing their case.
We think that is a demonstration of the appearance of actual bias.
San Agustin's defense attorney William Brennan arguing before justices Monday, highlighting a Facebook post made by now Attorney General Doug Moylan during his campaign. Moylan then including Lamorena as a professional reference. The presiding judge was handed the case after Judges Vernon Perez, Maria Senzon, and Alberto Tolentino recused themselves due to conflicts. But Lamorena was apparently unaware his name had been used during A.G. Moylan's campaign.
How can it be an endorsement when he didn't know?
It's the perception of the endorsement, Your Honor. Again, it's an objective standard. We're not looking at, do we need to punish a judge? Judge Lamorena has no right to sit on the case. We're not looking at, do we need to find something to find that he did something wrong? That is a discipline question. That can be addressed before the proper forum. The question in this case is objectively, would a reasonable person question his impartiality? We think it is an endorsement in that regard for that purpose.
I accept Judge Lamorena's statement that he was not aware of this, but when he did become aware of it, he should have immediately taken action, and he didn't.
Attorney Pat Seville represents Nadeau. Seville also questioning how recused Judge Tolentino was able to get back on the case.
I'm concerned about the Superior Court, as the Superior Court, taking a position that is just way out in left field. That it is the question you just asked, that, well, a recused judge can sit on a disqualification motion. There is no authority for that. It's not a practice that any other judge that I've encountered so far in the Superior Court has endorsed or followed. And even more preliminarily, I suppose, how did this get reassigned to Judge Tolentino?
It's concerns the justices had for Judiciary Staff Attorney Susan Hinkle. Hinkle saying judges are selected at random.
Your Honor, the tradition and the practice as it was explained to me is that judges are not automatically disqualified based on a prior disqualification, even when the case is assigned for a recusal question.
In the same case?
In the same case. So just
I don't know who explained that to you, but I question that advice.
Justices even cautioning Hinkle before allowing her to further respond.
And if we were to follow your position, we would allow judges who have been recused to come in and affect the decision maker in this case. Is that really what you're asking us?
I just want to clarify what the point of the that argument is. It's really our point is that the discretion is on the judge. The clerk of court should not divest that judicial discretion from the judge by automatically removing a judge based on a prior disqualification.
So you're asking us to make sure it's very clear in a rule, rather than exercising common sense, that this is the way it should be. That's what you want us to do, right?
It's essentially, if the Supreme Court would like to clarify the rule, then again, the Superior Court is bound by that. So if the Supreme Court wants to clarify it, then yes, in that manner.
But that argument only pushing defense to call for their requests to be granted.
So if we're going to use some unspoken policy and some backdoor conversation in how to assign cases where we feel we've been prejudiced under the statute, that seems to be a due process claim that's starting to materialize. And we don't want to be that cautionary tale. My client just wants a neutral, an impartial arbiter.
Justices took the matter under advisement.